Hello, my name is Dawn. I'm a customer services team manager. I will be taking you through the introduction today. So first on to slide 4 about the purpose of this webinar. This webinar is all about vulnerable clients and also further applications. It will help you understand the challenges that vulnerable clients face and also how you can support them. So by the end of the webinar, you will have an understanding of the challenges faced by vulnerable clients, what steps you can take to support those vulnerable clients, your duty of care, how to reduce delays and the negative impacts on vulnerable clients, and lastly, best practice when submitting evidence and applications such as hardship applications. Moving on to slide 6 now, to give a bit of an introduction as to why we're here. So, as I have said, it is to bring awareness to the severe challenges faced by our vulnerable clients and how we can support them through the legal aid process. On Crime Customer Services team, we receive around 3,000 calls every month. The most challenging calls we take are definitely from our vulnerable clients. Some of these calls involve suicidal threats and many clients are suffering from mental health issues. Customer Services team has been specifically focusing on reviewing calls from vulnerable clients, not only to identify trends, but also to look at what we can do to improve our service for these individuals. We recognise the difference it can make to a vulnerable person if these applications such as changing financial circumstances or hardship applications are submitted promptly. We will be looking at this later on today. I am now going to pass you over to my colleague Fatu, who will be looking at vulnerable clients in more detail and the types of vulnerability.
Thank you, Dawn. Who are vulnerable clients? Vulnerable clients are people who have additional needs or difficult circumstances that make it harder for them to get the information or support they need. They might find legal aid process confusing, struggle to communicate clearly, or become overwhelmed by stress. They often need support and guidance to navigate the system. Slide 8. There are different types of vulnerable adults, but we'll look at these 3. Health-related vulnerability. These are callers who have conditions that affect their ability to process, understand, or act on information. For example, they may suffer from mental health condition, they may have a learning disability or physical disability that limit their communication, for example, hearing or speech difficulty. They may struggle to understand complex information, remember details, or express themselves clearly. Social and demographic vulnerability. These callers are disadvantaged due to their age, isolation, or social factors. For example, an elderly client who's living by themselves and they have memory issues, or people that have limited social support network. They may lack advocates or struggle to navigate systems or feel intimidated when seeking help. Situational vulnerability. These are callers who are in crisis or stressful life event that makes them temporarily less able to cope. They could be survivors of domestic abuse or violence, people facing homelessness or financial crisis. Their emotional state may overwhelm them, leading to stress, panic, or difficulty on focusing on what to do. Here are some of the impacts of vulnerable callers. Ethical concern. Failure to submit a change in financial circumstances or hardship application can be considered professional negligence or breach of duty of care. This may lead to complaints or even applicants reporting to SRA. Stress is another factor. Vulnerable applicants are often already under pressure due to their mental health issues or other issues that they're facing. Fail to submit a change in financial circumstances or hardship application when required will increase applicants' emotional and psychological stress that can lead to a mental breakdown. Deprived is another factor. Applicants do not realize that a legal aid weren't notified of a change in financial circumstances when required. By the time they realize this, oftentimes the case is already concluded, when no application will be considered at that point. Therefore, they are liable to pay contribution. The last one is financial strain. Without a change in financial circumstances or hardship application, applicants are expected to pay contributions which they cannot afford. This leads to debts, enforcement, bailiffs, and further hardships. This slide gives us few real examples of the type of vulnerable clients we regularly hear from in the customer service team. These examples show the range of situations people face and how quickly vulnerability can escalate when process becomes very overwhelming. The first example, we will look at a vulnerable client receive a contribution order letter. Receive a call from a client with a history of mental health difficulties in a state of extreme distress after receiving a contribution letter. The client explains that she lost her job and her income has dropped significantly, and she did inform her solicitor of this change several weeks later. After the solicitor failed to submit a change in financial circumstances application, upon receiving this letter, the client becomes overwhelming, panicking, saying that she feels trapped and cannot cope. And with this financial pressure, alongside her ongoing court case, she begins to make suicidal threats, stating that she can't deal with this anymore. She reports that she felt alone, unsupported, and fearful of bailiffs because she cannot pay. The second example is an elderly mother contacted us regarding a contribution that was issued to her son, who is currently in prison. Her son was taken into custody shortly after the offense was committed, so therefore no income. However, legal aid application was processed on the basis that the applicant is working, and this was processed as per the information that was submitted. As a result, a contribution was issued, and now we're pursuing contribution collection by Advantis. The son has mental health issues, which is deteriorating in custody, and he's unable to manage the situation himself. The responsibility has fallen on the elderly mother, who is a pensioner and has her own mental health issues. The third example, the vulnerable client in hardship. A vulnerable client with severe anxiety and depression called regarding their condition. At the time of the assessment, the client was already experiencing financial hardship with high living costs and debt. The client informed their solicitor that paying the contribution was causing significant difficulties, including choosing between paying bills and buying food. Due to the client's mental health, they struggled to fully understand the process and relied heavily on their solicitor to act on their behalf. Although the client met the criteria for hardship application, the solicitor failed to submit one, as we were contacted when the case was already concluded. Applicant is still liable for the contribution, which worsens the client's financial situation. Another example is vulnerable client with reasonable adjustment. A client with learning disability contacted the customer service team regarding ongoing contribution. The client struggles to understand written correspondence and relies heavily on the support worker and their solicitor. The client experienced significant change in financial circumstances after losing their job, which meant they could not afford their monthly contribution. However, a change in financial circumstances was submitted outside the 28 days period. Although it was processed, the regulation meant that the change cannot be backdated. As a result, the client remained liable for the previous contributions that were process before the change was reported. The client becomes distressed and confused, stating that they believe that their contribution could have been removed entirely once the information was submitted. I'll now pass you over to my colleague. Thank you.
Thank you, Fateh. Now moving on to slide 11, which contains further examples of calls to the customer services team. So first off, we had a call from a vulnerable client who had a lot of mental health issues and was very volatile. They didn't know they had to pay a contribution and really struggled to understand our means assessment process, repeatedly asking questions. They didn't agree that they had to pay a contribution, and they felt very harassed by receiving the contribution letters. They couldn't afford the minimum payment that we encourage of £255 so that a break in the payment schedule is avoided. Another example is a vulnerable client that reported a change in their means. When the call handler checked, there was no change in financial circumstances received from their solicitor, and this prompted a number of ongoing chasing calls from the individual to escalate the matter and to request action be taken on their case to reassess their contribution. The vulnerable client was very distressed as they couldn't make the payments requested, and they were very frustrated about the delays the lack of action from the provider had caused. The third example is a vulnerable client being chased for contribution payments by Advantis, who are our debt collection agency. This individual had lost their job, but when we checked, there was no hardship or change in financial circumstances submitted for consideration. And now that the case had concluded, we could only advise this individual to set up a payment plan with Advantis. The client was very distressed and crying over the phone. There was a real fear that bailiffs would come to their door, and they were unable to decide what steps to take next. The fourth and final example is of a vulnerable elderly client who had no family support or friends to help them through the legal aid process. This vulnerable client was unable to understand the evidence requested to avoid a sanction, and an actual sanction was applied to their case. They said they didn't receive any letters and were really unhappy about the service provided from their solicitor and also from the legal aid agency. They wanted to make a complaint, and in the end, that's what they did. So let's now move on to slide 13, which goes through actions taken by the legal aid agency. This is to ensure that we deliver a high quality service to our vulnerable callers, many of which have complex needs. To support call handlers and the service we provide, we introduced a 7-step plan on how to handle self-harm or suicidal threats from vulnerable customers. This includes guidance on questions to ask, advice and encouragement that they should be giving over the phone, and when to alert emergency services. We also carry out regular training and guidance to support call handlers on how to deal with vulnerable clients and their differing needs. This is so that we can achieve the best possible outcome, acknowledge and respond in a way that makes our vulnerable clients feel listened to and understood, and also to help them have a better understanding of the situation and legal aid process. We also have set up a number of Microsoft Teams channels and chats. We have set up a number of Microsoft Teams channels and chats. For example, we've set up a chat to record high risk and vulnerable callers and to track their contact with the customer services team. It also enables the call handlers to alert other team members when they need support during a call from the team. So what have we done to support our vulnerable customers? First of all, we have been able to arrange welfare checks, especially for those vulnerable clients that are in prison. And we've even taken the steps to contact providers with our concerns, if appropriate. We have set up a number of urgent escalation processes to help us with vulnerable clients. For example, we have an urgent escalation to our national crime team. That is so that if there are any applications that need to be reassessed or processed, such as a hardship, we take steps to quickly resolve and get those applications considered, because this will benefit the vulnerable client. We've also set up an urgent referral route to our team that works with Advantis. This is so that we can put requests in to put a hold on enforcement proceedings, or when Advantis are sending out correspondence. But this depends on the specifics of a case and the level of vulnerability that the client is going through, as well as a consideration of enforcement action and whether that's already lodged with the courts. I'm now going to hand you over to my colleague who will be taking you through guidance on hardship applications.
Hello, my name is David Weaver. I'm the Senior Technical Caseworker on CAT2, also known as NCT, National Crime Team, and I've been on the team since 2006. I'm here to talk about applications for hardship review and eligibility reviews. So we should now be on slide 15. It says a hardship review is submitted on form CRM16 by email. This is for applicants who have failed the means test for magistrates' court case or have an income contribution in the Crown Court. They can also be submitted for applicants who have been assessed as financially ineligible for legal aid in the Crown Court as their assessed income exceeds $37,500 per annum. It's important that you note a CRM16 is not applicable for a change in financial circumstances, which needs to be submitted on CRM 14 and 15 through the portal. It's important in applications for hardship review that the form is signed and dated by the applicant and partner if applicable, and must be submitted while the case is live. Around 20% of our applications for hardship review are rejected because the form has not been signed correctly. When we receive a signed and dated CRM 16, we first review the original assessment for correctness. Evidence is required for allowable extra expenditure, as shown on the slides. For example, credit card bills, loans, car loans, for which we require the full terms and conditions with a termination clause, mortgages on additional properties. We can also take into accounts such as IVAs, individual voluntary arrangements, or fines, and this applies to both applicant and a partner if the applicant has one. Any revised income contribution is then backdated to the original assessment date, and so can assist vulnerable clients who have existing debts or arrears in other areas. So slide 16, this is for new applications following ineligibility, ANAFI. This is for applicants who have been assessed as ineligible for legal aid, and if they want to review after 21 days of the ineligible decision. In effect, it actually will be a CIFC, a change in financial circumstances, but as no representation order is in place, we can assess on a fully completed form for the Crown Court. This again is to be submitted through the portal on CRM 14 and 15. As with all applications for the Crown Court, evidence is not required at the initial submission. You can also submit a CRM 16 for an eligibility review if you consider that the client would still possibly fail the means test. If an applicant comes into scope on an AFI, the representation order will only be issued from the date of the NAFI. Now on slide 17, this is to discuss eligibility reviews, on which we can consider extra expenditure the same as on a normal hardship review. These are also submitted by email on form CRM 16. However, we can also take into account the estimated case costs for a private fee-paying client to see if these are higher than the assessed disposable income or would reduce the disposable income below the threshold of 37,500. These costs, however, are not used in the actual assessment and so do not affect the level of the income contribution. This means that although a defendant may come into scope, they could have a considerable contribution from income. An eligibility review must be submitted within 21 days of the original refusal notice. If not sent within that period, then a new application following ineligibility, which I mentioned earlier, should be submitted through the portal. There's also the possibility of an eligibility miscalculation application if it is considered that the means assessment is incorrect. No form is needed for this. The best way is to email us with the subject matter eligibility miscalculation. This could be due to a legal aid agency error, incorrect figures provided by the client, or if further evidence clarifies the information previously provided. An eligibility miscalculation must be submitted within 21 days of the refusal notice. Otherwise, the other option is a new application following ineligibility. From the slides, it can be seen that more than one process may be completed. For example, with an eligibility review, we can also check the original assessment, which can mean a different outcome due to being treated as an eligibility miscalculation. Again, the same could apply with a new application following ineligibility. You can submit a CRM 16 with that through the portal if you feel like your client might still be ineligible for legal aid.
Hi, my name's Andrew Lowe. I'm a senior caseworker for the National Crime Applications team in Nottingham, and I'm here today to talk to you about changes in financial circumstances for vulnerable adults. So there are two types of change in financial circumstances, although both use the same form. The most common is a change in circumstances after the date stamp. For example, the applicant losing their employment after the date stamp. The other type of CIFC is a change to an original application that contained a mistake. For example, if council tax was declared to be £228 per year instead of £2,280. So for changes that occur after the date stamp, even if it's only by a day, we will require a fully completed application. This includes evidence of all changes if there are more than one. There is a 28-day time limit on these applications. If we do not receive a fully evidenced and completed change in circumstances within the 28 days of the change occurring, we will not be able to backdate and the change will be processed from the date we received the application. This also applies to rejected applications, so if your application is rejected back to you, the 28-day time limit still applies and you will need to get it resubmitted before that 28-day expires. It's also important to note that the liability for contributions starts immediately after legal aid is granted. This means that a change after the date stamp will only affect payments after the current liability period has concluded. For example, if an applicant is granted legal aid on the 1st of January, they become liable for their first payment on the 1st of January due to be paid before the 1st of February. A CIFC for a change on the 10th of January will not impact that first payment. It's also important to be aware that changes which increase the applicant's contributions will always be backdated to the date of that change. And if this means that they have underpaid, then a payment plan can be set up with our debt recovery company, currently Advantis. For changes regarding incorrect assessments, where the original application contained a mistake, evidence to show the correct information is required. The evidence can be sent in an email to the relevant crime applications team or submitted through the portal as a new application. If submitted as a new application, please select the option Change in Financial Circumstances. Regardless of the method used, the change will be backdated to the beginning of the case, as long as a clear explanation is provided. If the applicant has already paid their contributions and the new evidence shows they have overpaid, then a refund will be issued for the extra payments. However, if the change results in an increase to their contributions, then they will be liable for those extra payments. So now I'm going to talk to you about what to do if you are unable to obtain the evidence within the time limits. So while the time limits for these applications will be enforced the majority of the time, there is some room for discretion where it's appropriate. So if you or your clients are unable to obtain the evidence prior to the deadline, there are a few things that you can do. First, please tell us as soon as possible. This can be by email or a call to our customer services team. If we are informed before the deadline expires, we are much more likely to be able to accept any explanations for the delay. Second, tell us what attempts have been made, ideally with evidence of those attempts, such as emails or letters sent, dates and or times of phone calls made, etc. And thirdly, explain what the issue is that is delaying the evidence. Without an explanation, it's very difficult for us to justify the use of discretion in these cases. So I'm going to quickly talk about how a CIFC is processed. So when a CIFC is received, the first thing a caseworker will do is open the original application. This means that the MAT number is very important, especially if the applicant has a common surname. Next, they will discern what has changed from the original application. If you can provide a short note explaining what has changed, this will be of a great help. We will also need to know how the applicant is continuing to support themselves. For example, staying with family after losing their employment. In these circumstances, we would need a P45 or letter from the employer showing the loss of employment, as well as a declaration of any money, if any, is received from friends or family. They will then review the evidence of this change. If they are satisfied that the evidence meets the minimum requirements and has been received within 28 days of the change, then they will reassess the applicant's means and backdate the change. If the evidence meets the requirements but was received more than 28 days, including weekends and bank holidays after the change took place, then the assessment will be dated from the date the CIFC was received, not when it was processed. Note that where the change results in an increase to contributions, the change will always be backdated to the date of the change. The 28-day time limit only applies to changes that reduce the applicant's contributions. Once the assessment is complete, the caseworker will send any relevant correspondence, such as contribution orders or notices, and review whether the representation order or refusal notice is still appropriate. If the change results in a change in representation, for example, they are now eligible for magistrates court representation, then a new representation order or refusal notice will be issued. However, if the existing order remains applicable, then no new one will be sent. If the evidence is not sufficient, then the caseworker will reject the application with an explanation of why the evidence was not sufficient and what evidence is required. Please note that evidence of all changes must be provided for the application to be processed. For example, if the applicant's rent has increased and they've split from their partner, but only the rent has been evidenced, then the application will be rejected for evidence of all of the changes. So finally, for me, I'm going to talk about submitting further applications for vulnerable defendants. So if your client is remanded in custody or sectioned under the Mental Health Act, is their employment or self-employment likely to continue, or is a CIFC going to be needed? We can't make that assumption, so we need you to confirm if it does change. And please tell us as soon as an issue arises, and provide evidence of attempts made, as well as explanations of why those attempts were unsuccessful. If you're unsure of the best next steps, then you can call our customer services team or email the crime applications team that dealt with the original application. The relevant team will be at the top of the representation order or refusal notice that's been sent to you. If the applicant loses their job but has not been remanded in custody, we will need to know how they are supporting themselves now, and we won't be able to process CIFC without that information.